The firm I worked for at the time of COVID, like a lot of firms, had everyone work from home. And up to that point, I'd been suffering from sort of anxiety and so on in the office, but I hadn't said anything to anybody. What happened was that there was a gradual phased return to work, as there was for a lot of people, and now they are saying about really returning, and I made a representation request that went back to 2020 through emails and so on to the managers and so on, and I've made a formal now representation. It's been rejected on 2 grounds, which I can succinctly put, because they're the actual words. They said an inability to meet customer needs. Now, the firm I work for is we're not front of house or anything like that. We don't meet people, we don't meet clients, we don't do any of that. The work we do is to do with the actual paperwork and so on.
Yeah. What was the other reason, Dean?
The other reason was an inability to reorganise a rota amongst existing staff. Now, there aren't many staff, but and we're only required to come in up to 40%, I think it is, at the time of each staff member anyway. Yep. We're not coming in
Dean,
full time.
Can I ask what you actually do?
I'm a proofreader for a firm of solicitors.
Okay. And why does that... I mean, that doesn't need to be done from the office, does it?
Well, not in my opinion, no. I think it's...
Why do they think...
Well, the thing is that the one theory is that the firm of solicitors has contracted us out to another firm who are not solicitors, but we're contracted out. We've been twice contracted out now. We're 2 removed, as it were, from the original job. But we're still essentially doing the solicitor's work, obviously, because we're doing the legal documents. But we've been contracted out.
But why do they say it's necessary for you to work in the office?
Well, it's not clear whether the solicitors are the people insisting on it or the people we now work for are insisting on it to please the client who are the solicitors. So I don't know which way around it is. That's a bit hidden.
All right. So. I will tell you this, Dean, although I'm interested in the reason, it actually doesn't matter very much because I'm afraid the law isn't on your side here. I'm going to explain why. There are 2 grounds on which people have a right, in inverted commas, to flexible working. The first is if they are a person with childcare responsibilities, a woman with childcare responsibilities, and they're being required to work full-time when the job could perfectly well be done part-time from home, and the insistence that they work full-time from the office has an unfair impact on women as a group, women tending to have primary childcare responsibilities. That's not going to apply to you for the very simple reason you're a man. The second way in which you have a right, in inverted commas, to work, to get flexible working is through something called the statutory right to request flexible working, which is a right brought in about 10, 15 years ago now, but it's a very soft right. It's a unenforceable right in the sense of what the law says is that you have a right to ask and you have a right to have your request considered, but you don't have a right to get. And as long as the employer has gone through the process of meeting with you and giving you a decision within 3 months and giving you a right of appeal, there's nothing you can do. The law specifically says that there are 8 potential reasons the employer can rely on, one of which is inability to meet customer needs, and another of which is inability to rearrange existing rotas, which are exactly the 2 reasons they've given for you. And bizarrely, I think this is outrageous, but bizarrely, tribunals aren't allowed to actually look at the employer's explanation and say, that's a good reason, that's not a good reason. All the tribunal can do is say, did they hold a meeting? Did they give an answer within 3 months?
Sorry, but the follow-up question is that I've now got literally 1 week left in which to lodge an appeal, which I've been given an email address for somebody, a manager at the firm, to lodge an appeal to, which I'm going to try and do at least. But do you think I have any leg to stand on at all then with this appeal? Because the thing is,
I don't know. I don't know whether
anxiety and things that go back years. You see, it's not just me bringing it in now and dragging it in. I've explained all that to them.
Yeah. Well, that does bring in another issue. But let me deal with your question first. The fact that you've got an appeal is a legal right. I don't know whether they're going to grant the appeal or not, but as long as they go through the process of giving you an appeal hearing if you ask for one, you don't have a claim legally, I'm afraid, because the whole thing about flexible working is very process driven. It's just about the process. However, Dean, I hadn't picked up on the anxiety point. Thank you for reminding me. You do have a right to have reasonable adjustments made if it will enable you to work, if you wouldn't be able to work if those adjustments aren't made. To put that in slightly clearer English, if you're severely impeded from going into work, even 40% that they're asking you to do because of your anxiety, but working at home would allow you to work, and it's reasonable to allow you to work from home and the job can broadly be done, your employer does have an obligation to do it under the Equality Act. So that might be the basis on which to do it. Have you told them yet that you're disabled? That you suffer from anxiety?
Oh, yes. That's formed the basis of my claim since 2020 when I sent emails to managers. Okay. So they do know it. They have a duty to make reasonable adjustments. If you don't win the appeal, Dean, I would contact a Citizens Advice Bureau or a firm of lawyers. I will recommend a firm of lawyers to you. The leading firm in the country for doing disability discrimination work is called DIDLAW, DIDLAW. They're the top firm in the country. They're the people to contact, and they'll be able to help you. Like all law firms, sometimes they'll want to be paid an hourly rate. Sometimes they'll work on a no-win, no-fee basis.